Good evening. I'm Jim Nathan, a co-founder of Floridians for Democracy. I'm joined by Karen, the inspiration and driving force behind our efforts to help protect and preserve democracy and freedom. We're honored by your presence on a very timely subject. Can the Supreme Court protect our democracy? Actually, I know most of us want to know, will the Supreme Court protect us? We ask our presenters to provide their thoughts on what we can do individually and collectively to help preserve democracy, in addition to comments. So listen carefully, and then remember, whatever you might learn, we cannot be silent. These opportunities for education are not just to go home and say that was interesting. It's what are you going to do with it? This program is being recorded. It'll be placed on our Floridians for Democracy YouTube channel, and hopefully it'll be posted by tomorrow sometime. I want you to encourage others to watch and learn and to speak up, not be silent. We're in what is now called Zoom focus mode. You can see the presenters and yourself, but not all the participants. You can submit your questions in the chat to either Bill Petrarca, an FFD co-founder, or me, and we will present them during a Q&A period. Later, we will leave the Zoom focus and all the small Zoom boxes will open up, and time permitting, we'll have an open Q&A session where you can use the raise hand button on your screen. That'll place you in the order of when you raised your Zoom hand. It's now my honor to introduce to you Howard Simon, one of our special board members, who has devoted his career to improving our American dreams by serving for nearly 50 years as an ACLU state executive director, first in Michigan, and more recently, the last quarter century or so, as the leader of Florida's ACLU. Howard will introduce our impressive high-energy presenter, Bob Levy. Howard, it's yours.
Thank you, and good evening, everybody. As Jim Nathan said, I am Howard Simon, and for the last 23 years or so, I served as the executive director of the ACLU of Florida, and for about another 24 years before that, the director of the ACLU of Michigan. And following my retirement, I joined the board of Floridians for Democracy. Many of us usually think of the courts, and especially the U.S. Supreme Court, as the protector of our freedoms and the last line of defense against assaults on freedom coming significantly from the second Trump administration. The question now, of course, is whether this will still be true. In the last several months, through what has been called the shadow docket or the emergency docket, the Supreme Court has put on hold a number of injunctions against emergency orders that were issued by the president, thereby allowing much of Trump's domestic agenda to go into effect while challenges to their constitutionality wind their way through the trial and appellate courts, which may, of course, take a year or two. During this time, the executive branch agencies will be allowed to fire thousands of government employees, cancel numerous grants that support essential scientific research, deport, correctly or not, thousands of immigrants, many rounded up on the basis of little more than their Hispanic ethnicity, or that they are heard speaking Spanish, or that they are at job sites that typically employ immigrants like construction or landscaping. This all raises a number of questions. That is the big picture within which our speaker is going to make his presentation. Is the court giving too much power to the executive branch, upsetting the delicate balance of powers that has kept our democracy from going off the rails? And secondly, has the Supreme Court become just another partisan branch of government? The timing for this evening's program, I think, is very fortuitous, with the next term of the U.S. Supreme Court set to begin just in about 2 weeks. So this evening, we will look at a few of the major decisions of the Supreme Court's last term, decisions that impact mostly on human rights. and preview some of the key cases that the court will deal with in this coming term. We will be unpacking all of this with the help of one of the nation's leading constitutional scholars, Robert Levy, the former chairman of the board of directors of the Libertarian Cato Institute. Bob has been a friend of mine, and I have benefited greatly by his analysis over the years, though we sometimes, not too often, disagree. That is because, I have to say, there's a difference between libertarianism as advanced by the Cato Institute and civil libertarianism as advanced by the ACLU. We may get into that a little bit later. But Bob's legal analysis has always been fair and informative. He is a scholar who respects the consistent application of constitutional principles. We're fortunate to have him with us this evening, and without any further delay, I want to turn the Zoom over to my friend, Bob Levy.
Hello, everybody, and many thanks to Howard and to Floridians for Democracy. It's a real pleasure to participate in today's discussion. So, as you've just heard from Howard, I served for many years as chairman of the board at the Cato Institute, a libertarian think tank headquartered in Washington, D.C. And so, for a context and for full disclosure, let me say just a word or two about libertarianism. I'm not referring to the political party, but to a political philosophy devoted to private property, free markets, individual liberty, and limited government. At Cato, we don't endorse candidates or parties. We're critical of both Democrats and Republicans, but we do have a consistent, I'd call it minimalist view about the proper role of government. Conservatives agree with us on many fiscal issues. Liberals agree with us on many, perhaps most, social issues. So does that mean libertarians are philosophically inconsistent? No, we would argue that it's conservatives and liberals who are inconsistent. Conservatives want less government control of the economy, but more government in the social arena. Liberals are just the opposite. They want more government control of the economy and less government in the social arena. Libertarians want small government across the board, a government that stays out of our wallets and out of our bedrooms and out of foreign entanglements unless our vital interests are at stake. In other words, we endorse a principled consistency regarding the strictly limited role of government. So some Americans believe that our modern civilization has led to a degree of moral decline. The libertarian answer to that problem is not for government to dictate what's moral. It's a short step down that slippery slope toward government regulation of what I can read, with whom I can or must associate, what foods I can eat, what I can say or write, and what religion I should follow. So the principle is straightforward. Libertarians believe we should be free to live our lives as we choose, as long as we don't interfere with other people who want to do the same. In a nutshell, adult individuals have the right and the responsibility to decide important matters about their own lives, but they may not infringe on the equal rights of others. Government's role is to secure individual liberty, not to mandate moral standards or personal choices. Okay, so with that quick background, today's topic is the Supreme Court and the preservation of democracy. So first, I'm going to examine President Trump's agenda and the role of the courts, including a few words on our system of checks and balances, as well as recent concerns over what the right has recently complained about as judicial supremacy. Next, turning to the court, I'll comment on the so-called shadow docket that Howard referred to. And then I'm going to summarize 4 of last term's key cases involving nationwide injunctions, medical treatment for transgenders, parental control over school books, and Planned Parenthood's access to Medicaid funding. That'll be followed by a preview of 3 cases that are likely to be resolved during the court's upcoming term, starting, as Howard pointed out, in a couple of weeks. And those cases will involve gerrymandering, deportations under the Alien Enemies Act, and birthright citizenship. Finally, a couple of concluding remarks on the remedies that are available if a president were to ignore a court order, how we arrived at the imperial presidency, and what should and can be done about it. Of course, all of those topics warrant extensive treatment. So today, my goal is simply to introduce some of the problems and controversies. Let's begin with the Trump agenda and the judiciary. A centerpiece of President Trump's second term has been to expand executive power at the expense of Congress. To date, the major check on that plan has been intervention by the courts. More than 400 lawsuits have been filed against the administration in 2025. Dozens of judges appointed by both Democratic and Republican presidents, including some appointed by Trump, have ruled against him, using blunt words such as egregious, brazen, and lawless. Those opinions have sparked debate over the proper role of the judiciary. Are courts the final guardian against executive excess, or has the judiciary itself become too powerful, encroaching on key executive functions? The too powerful view has been promoted not only by Trump himself, but by former presidents as well. The debate hinges on 2 checks and balances embraced by the framers. First, federalism, specifically the 10th Amendment, which provides that powers not delegated to the federal government or prohibited to the states are reserved to the states or directly to the people. After the Civil War, which was fought in large part because some states abused the rights of Black people, the role of the federal government expanded. Under the 14th Amendment, the federal government was authorized to intervene whenever a state violates certain guaranteed constitutional rights. The second check and balance, especially germane to Trump's nonstop battles with the courts and his occasional battles with Congress, the second check and balance is separation of powers. To illustrate, the president can veto legislation and nominate federal judges. Congress can impeach the president and confirm his high-level appointments. Federal judges can overturn Congress's laws and agency regulations. So each branch is a check on the other 2. Our current president, much like his predecessors, relishes compliant courts rather than judges who seek to curb his programs. Accordingly, he claims that the judiciary, exercising its power to say what the law is, has attained supremacy over the other 2 branches. And that's why he says he's justified in sidestepping court rulings, usually by adopting different procedural means to accomplish ends that the courts have rejected. And yet there's little support in the Constitution for the notion that the judicial branch is paramount. It's the legislative and executive branches that can both create and extinguish the trial and appellate courts. Even the Supreme Court's appellate jurisdiction is subject to, and I quote from the Constitution, such exceptions and under such regulations as the Congress shall make. Trump's response to the barrage of lower court injunctions against him has been to call for the impeachment of federal judges. He said they are lunatics guilty of sedition and treason. Some critics fear that he'll vent his frustration by appointing to the bench political hacks who commit to rule in his favor. If he were to succeed at that, it will be executive supremacy, not the judiciary, that will be threatening our liberties. And the question whether separation of powers will check a runaway president will depend on the unlikely emergence of a congressional backbone. For now, the Supreme Court is final, even if it's not infallible. The court's independence insulates it from most political pressures, and there are, I believe, sufficient cross-checks among the three branches to foreclose supremacy by any one branch. Now, that said, there are legitimate concerns about allowing lower courts to issue nationwide injunctions. But before we get to that question, let me turn to the Supreme Court with a recap of its latest term, talking about the so-called shadow docket and a few key cases. There have been, by my count, 20 Trump-related emergency orders issued by the Supreme Court. 17 of those 20 have favored the president. But we should remember that the administration asks the Supremes to step in for these emergency orders only when the administration feels that it's likely to prevail. Emergency orders are examined on this so-called shadow docket, which refers to the court's long-standing practice of issuing important interim rulings, often without full briefing, without oral argument, and occasionally, mostly, without written opinions. The orders are usually effective only until the justices, have more time to rule on the merits of the case. Proponents of this process argue that the court occasionally has to act quickly. For example, election disputes, death row cases, and occasionally the court has to rein in lower court judges who have exceeded their authority. And remember, these emergency orders, they don't create binding precedent. They typically involve only temporary relief. Nonetheless, unsigned and unexplained decisions sometimes have major national consequences, thus eroding public trust and masking some very important legal principles. That can lead to unpredictability and to the perception of arbitrariness or bias by the court. Critics also argue that the shadow docket sidesteps the lower court's adversarial process, which is really crucial for informed decision-making. The problem has no doubt been exacerbated by Trump's aggressive use of executive orders and Congress's continued abdication of its lawmaking function. If the court were to rein in executive orders and demand legislative clarity, the shadow docket might be restored to addressing true emergencies. Okay, that brings me to 4 of last term's cases, each of which is likely to have a significant impact on the country. The issues include universal injunctions, which I mentioned a moment ago, as well as the treatment of transgenders, parental control over school books, and Planned Parenthood's access to Medicaid. Obviously, I won't be able to explore all the details. These are complicated cases, but I will try to hit the major themes. Let's begin with the pivotal emergency order on nationwide injunctions. Individual plaintiffs and several states convinced 3 district courts to issue universal preliminary injunctions that barred enforcement of Trump's executive order ending birthright citizenship. Here's the issue. Can a single judge issue an injunction against the executive branch that covers persons who did not sue and jurisdictions beyond where the court is located. At the end of June, in Trump v. Casa, C-A-S-A, the Supreme Court significantly restrained district courts from issuing universal injunctions, but declined to rule on the constitutionality of Trump's executive order ending birthright citizenship, a topic we'll return to in just a moment. Justice Barrett, for the 6 conservatives, stayed the injunctions by the district court to the extent that they were broader than necessary to provide complete relief to the plaintiffs in those cases. She wrote that the law did not grant courts authority to issue universal injunctions, nor were such injunctions available historically in the United States or even under British common law. In addition, said Barrett, curtailing universal injunctions would discourage plaintiffs from forum shopping, that is, selecting those courts where the judges would be most likely to rule in the plaintiff's favor. Bottom line, the injunction in these cases will still be applied to the children of the women who were plaintiffs in these cases. But the injunction, again, these are birthright citizenship cases, the injunction will not be applied nationally. That doesn't bar universal injunctions altogether. They will still be permitted in 3 circumstances. First, if it's the narrowest way to adequately protect the plaintiffs. Second, by use of class actions that meet certain rules. And third, in cases brought under the Administrative Procedures Act, which allows judges to overturn agency regulations. So here's what's likely to occur. More cases are going to be filed, more work for the Supreme Court, the Supreme Court can issue universal injunctions, and more suits by state attorneys general who can get statewide and sometimes national relief. In fact, less than a month after the Supreme Court's ruling, several courts found ways to obtain universal injunctions preserving birthright citizenship unless and until the Supreme's rule for President Trump on the merits. My view, some situations require national uniformity. For example, building a border wall, regulating social media content, restricting mail order access to certain products. The resolution of those issues can't be limited to particular plaintiffs or particular jurisdictions. So I would have endorsed a slightly different solution, which was partly adopted by the Supremes. Namely, Congress should bar national injunctions by a district court unless, first, the injunction is needed to fully remediate an injury, or second, the government has violated clear controlling Supreme Court precedent. And third, Congress or the Supreme Court has provided an expedited appeals process so these matters can be resolved quickly. In our next case, U.S. versus Skirmetti, 3 teenagers, their families, and a doctor challenged a Tennessee statute that bars puberty blockers and hormone therapy for transgender teens. More than 20 states have similar laws, even though they directly impact less than 1% of the population. In Tennessee, the treatment is prohibited even if the parents want their child treated, and even if medical professionals think the treatment might help. So the questions for the court were twofold. First, does the law discriminate in violation of the Constitution's Equal Protection Clause? And second, if there's questionable discrimination, is it based on the patient's sex? Now that matters because sex is a specially protected class, which would prompt more rigorous scrutiny by the courts. Ordinarily, the federal government doesn't interfere when states exercise their traditional police power to regulate health and safety, particularly when it comes to children. For example, states have made it illegal for minors to purchase guns, cigarettes, and alcohol, even if they have parental consent. At oral argument, several of the conservative justices suggested, as they did in the Dobbs abortion case, that state legislatures, not federal judges, are best suited to evaluate these complicated medical issues. Justice Kavanaugh put it this way: the Constitution doesn't take sides on how to resolve medical and policy arguments, so why shouldn't courts leave those matters to the democratic process? Now, he might have asked, but he did not. Why shouldn't courts leave those matters up to the parents? On the question whether Tennessee's discrimination is sex-based, the state argued that men and women are treated equally. So while there may be discrimination against transgenders or discrimination based on their age, it's not based on their sex. Notably, classification by transgender status or age does not trigger heightened scrutiny by the courts. In June, Chief Justice Roberts, for the conservative majority, upheld the Tennessee law. He concluded that the ban is not sex-based, but simply excludes certain treatable conditions, namely gender dysphoria and identity disorder. Roberts further acknowledged the fierce scientific and policy debates about the safety, the efficacy, and the morality of transgender treatments. But he added, those questions should be resolved by our elected representatives. Now, paradoxically, in other cases, the rallying cry from conservatives has been parental rights without government meddling. And conservatives usually embrace consumer choice, even for ineffective products like collagen face creams, for example. The litmus test has traditionally been whether the treatments are harmful. And on that score, the science regarding transgender treatment is unsettled. And that, I think, is one reason the court deferred to the Tennessee legislature. If that's not enough of the culture wars, the next case also raises LGBTQ and parental rights issues, this time in the context of school curriculum and First Amendment religious exercise. And here's where we find conservatives endorsing parental control over the books their kids can read, even though they would let the state override parents when it comes to the medical treatment their kids can get. In Mahmoud versus Taylor, parents in Montgomery County, Maryland, wanted their children to opt out of instruction on gender and sexuality that goes against their religious convictions. The parents weren't seeking to eliminate the program, but merely to allow opt-out, which the county had previously permitted. Beginning in 2022, the county's elementary schools included books featuring LGBTQ characters in the language arts curriculum. Some Muslim, Jewish, and Christian parents objected on the grounds that their kids were being denied First Amendment rights to free exercise of religion. The Court of Appeals ruled for the county, explaining that the parents had not shown that exposure to the storybooks was a religious violation. In an opinion by Alito for the 6 conservatives, the Supreme Court held that requiring LGBTQ books infringed on the rights of parents to free exercise of religion. Lower courts had taken the too narrow view, he said, that only government compulsion to renounce religious beliefs would raise First Amendment concerns. The books in Maryland didn't go that far, but they were moralistic, not just descriptive, and teachers were encouraged to criticize alternative views. So the court required the school board to reinstate, for now, its notification and opt-out procedures. Unlike our previous case, involving transgender medical treatment. Parental rights, asserted this time through the free exercise clause, partly won the day with the conservative majority. Students won't have to attend classes if the books offend their religion, but parents still cannot select the books that affirm their religion. Only private or homeschooling would afford that full range of options. Next, let's turn to Medina versus Planned Parenthood South Atlantic, which addressed whether South Carolina could deny Medicaid funds to doctors or medical practices affiliated with abortion clinics. Planned Parenthood and a client filed suit to restore the funding that had been eliminated. They won in the Fourth Circuit, but the Supreme Court opted to consider a procedural question, whether the plaintiffs could sue in federal court to receive Medicaid dollars. Under federal law, Medicaid funds cannot ordinarily be used to provide abortions. But as we know, Planned Parenthood offers other medical services to women, including gynecological and contraceptive care, as well as screenings for cancer. In fact, the patient in this case went to the clinic for birth control, not for abortion. She argued that the Medicaid Act allows eligible patients to seek health care from any qualified provider. But South Carolina's governor responded that payment of taxpayer funds to abortion clinics for any purpose results in the subsidy of abortion, which violates federal law. Accordingly, he says, Planned Parenthood is not qualified to receive Medicaid benefits. 70 million Americans receive Medicaid dollars, and tens of thousands of healthcare providers participate in the program. So, resolution of this dispute has major implications. But the court faced two threshold questions. First, do organizations and patients have the right to sue states in federal court? And second, do federal laws that bar abortion funding also bar dollars to providers of other services? To prevail, Planned Parenthood had to win both of those, the procedural argument for a right to sue and the substantive war over government dollars. Justice Gorsuch addressed only the procedural question. Writing again for the six conservatives, he held that the Medicaid Act does not grant a private right to choose a particular Medicaid provider. Yes, the law says patients can get assistance from any institution that is qualified. But if a state decides that a provider isn't qualified, neither the organization nor its patient can challenge that decision in federal courts. According to the justice, to allow private enforcement in federal court, a statute must use clear and unambiguous terms, and, he said, the Medicaid Act does not do that. Congress is in control, said Gorsuch, not judges. Jackson dissented for the three liberals, arguing that when government benefits are provided, there's an implicit right to litigate issues related to receiving the benefits. That, in my view, is a close call. The 11th Amendment to the Constitution immunizes states against most lawsuits. But Congress passed Section 1983, which allows litigation against state officials, not the state, but the official, if a state violates individual rights guaranteed by either the Constitution or a federal statute. And regrettably, from my perspective, this Planned Parenthood case narrows the scope of Section 1983. Many libertarians, myself included, question the constitutional justification for the federal government to be involved in funding medical service. Nonetheless, once a right has been granted, as it has in this instance, Americans should be able to sue the government if the right is then denied. Sovereign immunity is an unwarranted limitation on the right to sue. It's derived from the English common law premise that the king can do no wrong. But the framers rejected monarchy and established a system that recognized a fundamental reality. Governments can and will do wrong. They must be held accountable, and truncating the scope of Section 1983 is antithetical to that goal. A proper understanding of the role of government dictates that Section 1983, the right to sue a state for violation of your rights, that be construed broadly, but sadly, that is not how the Supreme Court saw the Planned Parenthood case. Okay, that's a much abbreviated look at a few big cases from the court's past term. Now, let me switch to the upcoming term, which begins October the 6th. I'm going to preview three of the cases: gerrymandering in Louisiana, deportations under the Alien Enemies Act, and a topic that we've already mentioned in passing, birthright citizenship. The first case, Louisiana v. Calais, is about reverse gerrymandering. The state was ordered to redraw its congressional map to create a second majority black district. Previously, only one of 6 districts were black, even though 33% of the population was black. After the legislature complied by mapping a second district, non-black voters claimed reverse discrimination. In response, the state insisted that the redistricting process was driven not by racial objectives, but by partisan objectives in order to preserve the seats of a couple of Republicans. Now, ordinarily, courts do not intervene if they believe the goals are partisan rather than racial. And aside from demanding that districts have equal population, the courts recognize how difficult it is to establish equitable standards for redistricting. And that's why they defer to the political process when dealing with partisan disputes. But racial motives raise 14th Amendment equal protection concerns, which the courts rigorously review. If a redrawn district is viewed as race-based, the court would likely order a do-over and insist that race-neutral factors be applied, such as a compact shape, common interests of the residents, and physical boundaries, such as rivers, as well as political boundaries, such as county lines. By contrast, race-based criteria are designed to group people who look alike, implicitly assuming that they're going to vote alike. So how is the Louisiana case likely to be resolved? The court could go in several directions. First, the court could declare that the 1965 Voting Rights Act is unconstitutional, either because the 14th Amendment does not permit race-based remedies at all, or because conditions have changed and the Voting Rights Act is no longer necessary or even effective. That outcome would overturn 60 years of Supreme Court jurisprudence. Second, the court could hold that the Voting Rights Act does not require race-based remedies, but Louisiana violated the act by using race despite available race-neutral options. And third, the court could decide that the state's motives were permissibly political, partisan, not racial. The court's doctrine in this case will no doubt affect the gerrymandering disputes that are now underway and that have considerable electoral significance in Texas, in California, and in other states. So if redistricting doesn't spark your interest, maybe immigration will. In March, the D.C. Circuit Court of Appeals temporarily halted the deportation of alleged Venezuelan gang members under the Alien Enemies Act. Now, that act is applicable to countries at war with us. It hasn't been used since World War II, the Japanese internment case. Drug gangs are not a country, nor are they controlled by a country. We are not at war with Venezuela, and illegal immigrants are not mounting an invasion or incursion to seize power in the United States. If they were, the president could suspend habeas corpus, even with respect to U.S. citizens. So, bottom line, the government must not have free rein to arrest, detain, deport any non-citizen accused of criminal acts without, according to that citizen, due process. In April, the Supreme Court agreed 9-0 that due process is required, and thus these past flights to El Salvador were declared unconstitutional. The court didn't reach the question whether the Alien Enemies Act applied, but on September the 2nd, the conservative, probably the most conservative, Fifth Circuit Court of Appeals agreed with the DC Circuit and blocked Trump from using that act to deport Venezuelan migrants. The court concluded that there had been no invasion or predatory incursion by a foreign power. For now, if a detainee had an initial hearing and was declared removable, he can be deported without further process to any country that's willing to accept him and commits not to torture or killing. But stay tuned. Those are preliminary holdings, and this coming term, the Supremes will have an opportunity to tackle Trump's use of the Alien Enemies Act on the merits. Another hot button immigration topic, again, that we've referred to already: can the president eliminate birthright citizenship? Last term, as we discussed, the court weighed in on the use of nationwide injunctions, but didn't decide the birthright citizenship question. And that's very likely to come up this term. The 14th Amendment states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. The goal was to overturn the Dred Scott case, which denied citizenship to slaves and to their kids. The 14th Amendment included the phrase subject to the jurisdiction to deny citizenship to three groups of people: Indians, who were later granted citizenship by statute, children of foreign diplomats, and children of enemy forces in the United States. Neither of the latter two groups was subject to our jurisdiction. But the Congress surely did intend that children of permanent legal residents would be citizens. Indeed, the Supreme Court said so in U.S. versus Wong Kim Ark back in 1898. Still, that didn't resolve the status of temporary resident aliens, for example, students and tourists, much less illegal aliens. They are subject to our laws, at least while they're here, and they can be convicted of violations. So a natural reading of the phrase, subject to our jurisdiction, suggests that their children are citizens. But in 1868, when the 14th Amendment was ratified, there were few, if any, restrictions on immigration. So the birthright citizenship question, the issue, wasn't about illegal aliens. Subject to our jurisdiction might have meant primary and permanent allegiance to U.S. law and U.S. sovereignty. On the other hand, we had Confederate soldiers. They were not allegiant to the United States, and yet their children were clearly citizens. And many victims of the slave trade were brought here not only involuntarily, but illegally. And their allegiance was surely questionable. But their children were also among the intended beneficiaries of birthright citizenship. So my guess, the president is very likely going to lose this battle. All right, one last question, and that can be what can be done if the president were to ignore a court order. So subordinates who disobey court orders can be held in contempt. They can be fined. If they're lawyers, they can be disbarred. Yeah, the president can pardon criminal convictions, but he can't pardon civil contempt. Under Justice Department guidelines, a sitting president can't be prosecuted, but it might be possible to hold him in civil contempt, fine him, and even appoint an executor who could seize or retitle his property to be sold if the fine that was levied by the court isn't paid. Otherwise, if that doesn't work, and we don't know because this hasn't occurred, redress would have to come from voters at the polls in the next election, from Congress through impeachment, from a cabinet mutiny under the 25th Amendment, or perhaps by prosecuting the president after he leaves office. The imperial presidency has indeed become a problem. But the problem predates the recent power grabs by Donald Trump. George W. Bush exploited national security powers after 9/11. Obama refused to enforce marijuana laws and took actions on immigration that he admitted were unauthorized. Biden abused the pardon power, tried to cancel $500 billion in student loans, and it was Biden's Labor Department that unsuccessfully claimed unilateral authority to mandate vaccinations by all large private sector companies. He had the enthusiastic backing of congressional Democrats, willingly condoning executive overreach because their man was in the White House at the time. So the problem certainly exists under Donald Trump, but it goes beyond Donald Trump. The root cause is congressional abdication. The answer, in my view, Congress has to reassert its authority as a co-equal branch and revitalize its oversight and lawmaking roles as envisioned by the framers. And what can you and I do about that? Well, toward that end, I would urge every one of you to raise these issues with your families, your friends, your business contacts, to become active in public policy organizations and bear in mind that they are singularly adept at pursuing remedies for these concerns. So perhaps you might even consider donating to such organizations. Send letters to the editor. Write to your political representatives. Protest and express your views, of course, at the ballot box. Okay, that's my brief recap of the Supreme Court's role in preserving democracy. I think because of time constraints, I omitted a number of the really key cases from past term, and that would include public funding for charter schools, gun control, access by kids to social media, excessive police force, and a few others. But now we have time for further discussion, either about the cases I covered, the cases I did not cover, or if you'd like to pursue, I'm happy to discuss the president's crusade to expand his executive power. Many thanks for your time and for your attention.
Bob, thank you very much. That was really very, very informative, very good, very helpful. Thank you so much.
My pleasure.
Let me begin, and then I'll turn it over to everybody else who wants questions. It seems to me the most significant case that the court is going to hear in many, many, many terms is this case on birthright citizenship. You seem to be very optimistic that given the precedents that this court is going to rule against the president and not allow him to unilaterally amend the Constitution by eliminating birthright citizenship. I think this is such a serious issue because it's not only a change in the Constitution, it would change the character and culture of the country. What makes you so optimistic, given the fact that this court has set aside precedents in a lot of other areas, that they will adhere to precedents in the birthright citizenship case?
Well, again, most of the rulings in favor of the president have been on this emergency or shadow docket, and they are temporary rulings, and they reflect, I think, the court's tendency, as most conservative courts have been, to defer to the executive branch, at least until they have time to consider briefing and oral argument and address the issues more fully. Bear in mind that this conservative court fashions itself as textualists. They believe in the text of the Constitution. Well, if there's anything clear about the Constitution, it's the 14th Amendment's statement that anybody born here or naturalized here is a citizen. And this phrase, subject to the jurisdiction thereof, has already been addressed by the court, at least as I indicated, with respect to permanent resident aliens. And the extension of that to temporary aliens, I don't think does anything to change how the language of the Constitution applies to aliens generally. So if the justices are dedicated to their own judicial philosophy, as one would hope they are, and they abide by the text of the Constitution, then this should be a slam dunk. And frankly, I wouldn't be surprised if this is a 7-2, 8-1, or even, I mean, I'd hesitate to say 9-0, but I think it's going to be a victory for a defeat for the president.
Well, I hope you're right. Bill, do you want to open it up to questions from the audience?
I have
So
a couple.
Bill,
I have a couple that I need to share with you before we do that. So here they are. Some people are feeling that the Supreme Court has tossed many bones in Trump's support, so that when they stop him, he will have had some wins, but not the big one that destroys American democracy. Any comments on this?
Well, if I understand correctly, you're saying they've given him a few petty victories and that they ultimately will deny him the victories that really matter. I don't think I agree with that. I think the victories he's begotten have been on issues that are critically important. The only solace I draw from this is that those victories have been, again, on the emergency docket and have been temporary rather than permanent. So the distinction I would make is not between victories on unimportant issue versus what's likely to come on important issues. Rather, I think the issues are all important, but the difference has been temporary decisions without oral argument, without briefing, versus what is more likely to occur when there is the opportunity for briefing and oral argument. And we do, at a minimum at least, get the opportunity for evaluating a written decision to find out why it is the judges have reached their conclusions, rather than these one-sentence emergency orders that we're seeing come down. So I personally find it very disappointing that the court has been so deferential on the emergency docket, but I don't necessarily extrapolate that to indicate that they will be equally so when it comes to a merits decision.
Bob,
Thank
can
you.
I push back a little bit on that, because I'm a little hesitant to regard the allowing of the executive orders to take place on an emergency docket as less significant, because to think of the comment on the significant practical consequences of allowing some of these executive orders to take place, the consequences on people who can be deported or fired, or, I mean, they're going to have vast practical consequences for a year or two until the cases are resolved.
Mm-hmm.
That is certainly true, and I share that concern. I think there is at root an even broader question. The ground rules for executive orders ought to be, in my view, first, the president can issue executive orders if he has a grant of authority from Congress. Second, they're legitimate when they relate to his core powers in the foreign policy area, and particularly in the national security area. And third, if they deal with the internal workings of the executive agencies, then okay. But beyond those three categories, executive orders that affect the rights and rights and obligations of private parties, it seems to me should be unconstitutional. They aren't intended, they were never intended as a way for the executive branch to bypass Congress. So what's happened? Well, Congress, again, has abdicated and has delegated much of its authority. But bear in mind, I think not only has he delegated it to the executive branch, which liberals tend to disapprove of, and conservatives, in the case of Trump, approve of it. But when the liberals were in power, they approved of it under the Obama administration and the Biden administration. The other thing that the court has allowed is the delegation of this legislative power to the administrative agencies. The conservatives are trying to reverse that. I think we really do need to restore the notion of separation of powers, where it is Congress that legislates, not the executive, and not certainly these administrative agencies, which are unelected and unresponsive to the political process. So that there's the root cause, is this excessive delegation of Congress's power to both the executive branch and the administrative agencies. And I, for one, would very much like to see that reined in. Now, to the court's credit, it has moved in that direction with respect to the agencies. It hasn't moved yet in that direction with respect to the president. So you've seen what's called the major questions doctrine, which says that Congress has to be explicit when it's delegating its legislative authority on matters of major importance. And you've also seen the overturning of the Chevron doctrine, which gave these agencies quite a bit of wiggle room to interpret statutes when the Congress had not been clear in drafting the statute. So there is a movement toward reining in excessive delegation. So far, it hasn't reached the executive branch. I'm hopeful once some of these cases that are going to come up, particularly the two I mentioned, the Alien Enemies Act and the Birthright Citizenship Act, that we'll see the court finally stepping in and say, enough, we've had enough executive power, and it was never the intent of the framers that we would have this kind of structure.
Another question, Howard. Bob talks about this congressional abdication of powers. How much of that is the result of the Citizens United decision, which made the re-election of the congressional seats dependent upon the amount of money that they had, and so that actually. And then when you have a president who controls the amount of money a party provides, doesn't that lead to congressional abdication?
Well, there have been a lot of concern about Citizens United. Of course, it didn't help Ross Perot or Steve Forbes or Nelson Rockefeller or a number of other extremely wealthy individuals who thought they would attain political power just because they had a lot of money. So I don't think Citizens United has been dispositive, and I think it's also important to recall exactly what it is that Citizens United addressed. So there is still a prohibition on contributions by corporations and labor unions to parties and individual candidates. So what Citizens United addressed was the ability of corporations and labor unions to spend their own money on what's called independent expenditures. That is, to advertise on behalf of a candidate. That was limited in the past, and it's no longer limited. Now, corporations and labor unions can spend. But bear in mind that they cannot coordinate those expenditures with either the candidate or the candidate's party. So my own view is that if money is a problem, then there are two possible answers. One is even more speech that would at least offset or counterbalance the speech that's now being promulgated by these large moneyed interests. Bear in mind that some of these interests are on opposite sides of the political spectrum. You have corporations on the one side and you have labor unions on the other. And even within the corporate community, you had corporations like Whole Foods that very much supported Obamacare, for example, and others that very much opposed Obamacare. So there's some division of power there. I would like to see either more speech to counterbalance the speech that now exists. And bear in mind that the expenditure of money is an element of free speech. So it's not that money is speech, it's not, but money is necessary, particularly in today's climate where everything it costs a heck of a lot of money to make your views known. Money is necessary to get your views distributed across the country. So money is necessary, just as is it's necessary to have counsel in a legal proceeding. So it's not that money is a lawyer, it's rather that money enables the availability of a lawyer, just as money enables free speech. I don't think Citizens United is the root of the problem.
Howard, any comments from you?
Bob, does more speech mean public funding of elections?
Well, public funding is a form of compelled speech where there are First Amendment arguments against that as well. It would obligate me to pay tax dollars to publicly fund elections in support of candidates that, in fact, I oppose. So, no, I'm not in favor of public funding by.
Well, then how do you get more speech?
We get more speech by engaging more people in the political process. I have no objection at all to people expressing their views through groups, lobbying groups, corporations, labor unions, you name it, partnerships, uh, limited partnerships, anything that requires the pooling of funds is perfectly okay with me. I think we ought to eliminate all the contribution limits, let money flow to the candidates without restriction in terms of where the money's coming from. But let other organizations as well pool resources and fund political speech, just as do now corporations and labor unions.
Okay, good. One last question, then we'll open it up to the floor. What would it take to impeach one or more Supreme Court justices?
Well, they have to be convicted of high crimes and misdemeanors. Nobody quite knows what that means. And it has been done in the past. There have been proposals to impeach judges proposed by President Trump. He's called them lunatics, guilty of sedition and treason, and that's in response to more than 100 injunctions that have been issued by the lower courts against him. In fact, Republican lawmakers have even filed articles of impeachment against several federal judges. But those articles have gone nowhere, thankfully. And I don't believe they will go anywhere. And of course, it requires a supermajority in the Senate to convict, and that isn't going to happen.
Great.
Thank you. I'm going to ask Jim to come back in for questions, and
We're on, and we're just going to take questions based upon the hands raised. We have two. There was one person that had her hand up earlier, and I don't see it now, but we'll go with Jack and then Robin. Jack, you're on. You need to go off.
oh, wait a minute. I need to give him
Oh,
unmute. Okay, now I should be able to unmute himself.
yeah. Okay.
There we go. Thanks for putting this on, and Bob, thanks for a great presentation. Bob, in CASA, Justice Barrett's opinion said universal injunctions by district courts were not an equitable remedy permitted by the Judiciary Act of 1789.
Right.
Justice Jackson took the position that the judiciary is not constrained by that law. Many believe Justice Jackson is saying the Supreme Court is not bound by the law. Do you agree? And if so, is it fair to say her view is undemocratic because it says the Supreme Court can ignore a constitutional law it doesn't like?
Well, I don't believe the Judiciary Act of 1789 is so explicit about this. Um, it's been interpreted to mean that nationwide injunctions are not authorized because one would expect that a district court sitting on litigation filed by a particular plaintiff and sitting in a particular jurisdiction cannot bind other district courts. And that certainly is the usual state of affairs. But I don't find anywhere, I don't claim to have looked at this lately. I don't think there's anywhere in the Judiciary Act of 1789 an explicit statement that says that nationwide injunctions are prohibited. That said, I think it's a fair interpretation of the Judiciary Act of 1789 that judges sitting in a particular jurisdiction cannot bind other judges, much less even that bind appellate courts in another jurisdiction. So if you had a nationwide injunction, a nationwide injunction by a judge sitting in one district would bind the appellate court in another district, because the appellate court in another district wouldn't be able to overturn the first district court's injunction. So I think that interpretation of the Judiciary Act is certainly justified. But I do think that some nuance is the better approach. And when the text is not quite explicit, nuance sometimes serves the best alternative. And in this case, I think if a executive branch or a congressional statute violates clearly established constitutional law, that a nationwide injunction should be permissible, as it should be for issues that do require enjoinment across the country in order to provide complete relief to the plaintiff in the case. But I do think it's a very difficult issue, and the court is apparently grappling with it. And Justice Jackson, I think, had some basis for saying that the court should, in some circumstances, allow nationwide injunctions.
I had a second question, but I'll go to the back of the line and make sure everyone else can ask theirs first.
Oh, Jack, we just have one other hand up, so why don't you go now and then Robin?
Oh, okay. This goes to the name of your organization with the word democracy, and it's sort of a philosophical question, but I think it ties into the general discussion here. And it's to Bob. Are we a democracy where the purpose of government is implement the will of the people subject to following certain procedures and honoring the Bill of Rights? Or are we a constitutional republic where the purpose of government is to secure rights, both those in the Bill of Rights and those, quote, retained by the people, close quote, that are mentioned in the Ninth Amendment?
Well, certainly if we take the technical purist view of the meaning of democracy, rule by the people, or even in its more pristine view, one man, one vote, we are not a democracy. We are a republic. We have so many restraints on democratic rule, the Bill of Rights being the most obvious one, but also things like the Electoral College, the requirement for supermajorities to do things like impeach the president, ratify treaties, and on and on. So there are all sorts of supermajority requirements, exceptions to the rule of one man, one vote. And so we are certainly a republic. But I think when most people say protect our democracy, they're using democracy in a less technical sense to mean a free republic, which is controlled by its citizens. It's true that procedurally, sometimes it's not 51% of those citizens, but nonetheless, it is citizen control with checks and balances.
Thank you.
I'll take advantage of responding to Bob's last comment. When we named Floridians for Democracy, we've had people who have asked similar questions, Jack. And our philosophy is very much what Bob said at the end. We basically want to protect the general freedoms for the nation to decide and not to have a dictator tell us what we're supposed to think or do or act. And as we were trying to bring organizations together, we found the challenge on that side is that people might be focused on women's reproductive rights or focused on the environment or focused on racial justice, et cetera. But the response we had to give, if we lose democracy, all those issues are controlled by a small group of individuals or an individual that makes those decisions, and that's not the world we want to live in. And as we got to know Bob and a Cato emeritus person, we realized that while we may have some political differences on specific issues, we have a very common interest, and that is protecting the freedoms of all people in this nation and following the rule of law, which seems to be against it. So I think that's where we found commonality. So many of our programs and many of our educational efforts are to reach across the aisle and to realize that we have to build an American democracy constituency that works together, not fighting each other over their individual policy questions, but fighting for their rights to protect those questions and the ability to debate and negotiate for them. So it's an interesting journey. Thank you for that. We've got Robin, followed by Sandy, and feel free to raise your Zoom hand and come and join in on the questions for the next few minutes. Robin, you're up.
Can you hear me?
Yes.
Oh, good. Wonderful. Thank you again, Bob, for your wonderful presentation. I'm going to tie in a little bit with what Jack Painter and Jim were just talking about. The title of this program is can we count on the Supreme Court to protect our democracy? Well, that's the question that we've all been asking. We who are not steeped in legal language, we hear Trump talking about rigging the election next fall, bringing in troops, Marines, et cetera, and he would really prefer for us not to have an election, is what we all kind of can gather from that. And also, he has given rise to thinking that he should have a third term, that he should continue on as being our, in a sense, our authority, our dictator, our king. So where is the role of the Supreme Court? Where there has been excessive abdication by our Congress, our House, and our Senate, and it doesn't look to me anyway like that's ever going to change while he's in power. He's continuing on the road of Project 25 being his guidebook, his guideline, his North Star, and everybody else is going along with him. So I guess what I'm wondering about, and I think this is all terrific, what we've been talking about tonight, we cannot really count on the Supreme Court to save us, can we?
Well, I hope so. I hope so.
Okay. That's what we want to hear.
I hope so, and I'm optimistic. Now, I think I need to qualify that by saying this. The evidence that you might adduce that has been obvious until now is that the court has gone along with a lot of his executive orders. But the reason that's the case is because the court hasn't had the benefit of full briefing or oral argument. And it's been Trump and Congress by its abdication, Trump's by his aggressiveness, that has brought so much to the court that the court is unable to process it with dispatch. And it will have to take some time. I do think that when the court takes the time, that we will see a number of Trump's excesses reined in. Not all of them. I mean, I think, for example, this notion that he should have some control over independent agencies, I think that's correct. We had three branches of government: legislative, executive, and judicial, not four. Independent agencies are nowhere in the Constitution. So there's some justification for him assuming control. That doesn't mean that Congress can't put some limits on the extent of his control over independent agencies, as they could, for example, with the Federal Reserve System. But some of the stuff that he wants to do is at least for me, acceptable both in terms of law and in terms of public policy. I must say that not much of it, but some of it. With respect to a third term, by the way, the 22nd Amendment says that no person shall be elected to the office of the president more than twice. So he's floated the idea that he could run as vice president with Vance as running as president, and then Vance would quit and Trump would succeed him, and then Trump would not have been elected. He would have succeeded him without election. But the 12th Amendment says that no person constitutionally ineligible to the office of president shall be eligible to that of vice president. So is Trump ineligible to the office of president? It's an open question, but my guess is that this is all pretty far-fetched. It's maybe constitutionally unsettled, and that's because nobody's had the chutzpah to bring a case like
Who's
this
got the chutzpah?
before the court. And my guess is the court would reject such an obvious intent
Okay.
to circumvent the 12th and the 22nd Amendments, just as I think the court is going to reject this obvious intent to circumvent the birthright citizenship clause.
Oh, good. Thank you very much.
I guess we hope we're all not destroyed before that day happens. We will find out, won't we? Sandy Parker, you're up.
So, well, I want to say thank you to Jim and Howard and Bob for doing this. It's really such an important topic, and it's great to see everybody together. I want to go back to Bob, your optimism. I'm worried just about how much time there is between now and the 2026 primaries. We don't have time to wait for the Supreme Court to get around to hearing a lot of these issues. I'm particularly interested in all of the efforts to try and get mid-decade redistricting done. Texas looks like it's going to happen. California, I think, needs its voters to approve it. So I don't see how that's happening before 2026. Florida is talking about doing it, although it seems to me that contradicts Florida's Fair District amendments. I just don't know how to think about all this playing out, but I'm worried about the court running out our clock in terms of having any effect.
Well, look, I share your concern, and I just probably am a bit more optimistic than some of our audience about the extent to which the court will adhere to the rule of law rather than be bowing and scraping before the president's agenda. With respect to redistricting, of course, this has been a problem for as long as I've been alive, and we've lived with it. And the court has stayed away from it. The court hasn't gotten involved at all in partisan redistricting. The only attempt by the court to get involved has been when it's apparently racially motivated. And I don't know whether that will continue. I would hope the court would abandon that doctrine and get involved in partisan redistricting and start instructing some of these states that they have to have an independent, nonpartisan commission to make do these decisions. Now, the court's reluctant to do that because they don't find that there's anywhere in the Constitution that suggests that that kind of thing is necessary. But, the very essence of our rule of law in our republic is the electoral system. And if we corrupt it, then we're in big trouble. I don't believe, however, that the current redistricting issue is going to have such a huge effect. The assumption is that when you put people together in a district, they're all going to vote in accordance with either their racial proclivities or their gender proclivities or their education proclivities or whatever. But we've seen over the entire history of the country that the people vote differently. Not all blacks vote one way. Not all union members vote one way. Not all Jews vote one way. So I don't think, as good as some of these new algorithms are at trying to redistrict in a politically advantageous way, I don't think they're going to be successful at doing that in a big enough scale to alter the impact of an election. Now, bear in mind, one problem here is that we have a winner-take-all system and an electoral system. So let's assume you had a state that was 60% white and 40% black. And let's assume that the population was distributed randomly over all the districts, so that all the districts were roughly that. Well, you wouldn't get a situation where 60% of the Congress from that state is white and 40% black. 100% of the Congress representatives would be white because every district is 60-40. I'm assuming now that everybody votes in accordance with their race, but that's just not the case. They don't. And so all the districting in the world, I don't think is going to, I hope is not going to alter the outcome of our races. And particularly when you think about whenever there is redistricting that benefits one party, as there apparently is going to be in Texas, there tends to be some counterbalancing that goes on somewhere else. And so the net sum of the advantage is probably to be closer to zero.
Thanks, Bob.
Can
Yeah, last word.
Bob, I say this with all due respect. I've loved you and followed you and benefited from your, but boy, I think that what you just said is an excessively optimistic view of partisan gerrymandering. I think you have discounted the fact of how professional and successful partisan gerrymandering has become since the court ducked the issue in the Rucho case. The court could have stepped in and maybe have done something about it, but as a result of opening the floodgates, and if they should decimate or kill off what remains of the Voting Rights Act, and in this next term, and open the floodgates for more partisan gerrymandering, we will never have an effective democracy where your vote will count. I mean, what we have now is a situation where if you look at the congressional districts, a handful of districts are competitive. They're all very well designed by state legislatures to be non-competitive.
Listen, I don't dismiss what you say. I think there's a lot of merit in that. In my view, if the court decides that the Louisiana's motives in the case that's coming up were permissibly partisan and not racial, I would hope that the court would abandon the case that you refer to, the Rucho case, which basically says they're not going to get involved in partisan gerrymandering. The court should be involved in partisan gerrymandering. But you know, why is gerrymandering? Why is it that we think of gerrymandering as a bad thing? Remember, there are good aspects to gerrymandering. If you had a system that was not gerrymandered and the population was spread across the state, every single district would go to one party or the other, whichever party had a majority. And that would mean that you wouldn't get, as I indicated, a 60-40 miss. You get 100% to zero. Now, how do you avoid that? You avoid it by gerrymandering. So gerrymandering is something we need. We just need a better way of doing it. And I'm fully sympathetic to the notion that the Rucho case was a mistake and should be reversed, and the court should get itself involved, and we should have a neutral way, preferably by nonpartisan commissions. And a lot of states have done that. I think the number probably is close to 20 now that have done that, had commissions making these kinds of decisions.
I agree. I think the Rucho decision by which the court allowed partisan gerrymandering is one of the most destructive decisions for our democracy.
I'm in agreement.
And Howard, thank you for bringing the last one up. And I hope folks, you realize that kind of interaction, the discussion of tonight, you didn't agree with everything that everybody said, but our ability to have those discussions is vital for the lifeblood of the future of this nation. And to have that all be shut down is terrible. I'm going to share a couple things about two upcoming programs, and then I want to introduce a couple people to close out tonight. And then we'll stay on the line as we've done the last few months. For those who would like to stay and just chat on anything, we'll release Bob if necessary. If he wants, he's certainly welcome to stay with us. These educational programs are brought to you by Floridians for Democracy Institute, which is our 501c3 entity focused on education. And it's under our educational series called Speak Up for Freedom. On October the 8th, we're going to have a number of faith leaders, both in Florida and outside of Florida, speaking about confronting the immigrant detentions in Florida and the inhumanity that we're facing these days. And we also have an immigration attorney that will be a part of that discussion, and our co-founder Bill will facilitate that. So it's going to be not facilitate. We have a great facilitator from WGCU, but Bill's put this program together. And then on October the 20th, we will be working on a program called Happy Birthday Freedom, Protecting Liberty for All. And this is a new program that's emerging nationally in preparation for the 250th anniversary. And it's all about bringing people together, crossing political lines, religious lines, etc., to bring back this ability to negotiate, debate, discuss, and resolve important issues, just as our founding fathers had to compromise, and that compromise is not a dirty word. Our sister organization, Floridians for Democracy, that's our action-oriented organization. And they have a brand new program called Hear Our Voices Days. And the first one is tomorrow. So I'm going to call on Robin Cook, followed by Rose Gatens, to share with you a little bit about it. And then we'll thank everybody for this evening and then stay on the line. So Robin, you're up.
Yes, well, thank you. And Rose, I hope you'll join in with me. Everybody who is on the mailing list for Floridians for Democracy has received an email message yesterday, actually, for what we're calling Hear Our Voices Days. And that means that on one day every other week, we're going to try to urge anybody who can and who wants to stay at home, call your local legislator, or write them a note, or however you want to reach your local or state legislator. And we have scripts for you to use, meaning we have 2 or 3 scripts on 3 different major issues. The first one being vaccinations and how we want to maintain vaccinations. The second one is immigration detention. I heavily discussing or heavily thinking in the back of our minds about Alligator Alcatraz, of course. And then we have scripts for off-cycle redistricting. So Bob and everybody else, this is exactly what we were talking about tonight when Bob said, speak up, call your legislature, get together with collaborative partners. This is what we're trying to do. This is how we're trying to have people speak up for democracy in the privacy of their own home. If they don't want to go to October 18th, no King's Day, please join in and do this. Now, Jim, I'm not sure where this will show up for many of these people who do not get our emails. Will this be on the chat?
Thank you. So I'm putting it in the chat right now.
Wonderful. So if you go to where the chat is, Jim is inserting in the chat where you can get the link for all the different scripts that we've written for you, anybody that wants to do this. And we're sort of concentrating it in this Friday and one day. Doesn't mean you have to do it tomorrow. Please do it whenever you want. But we're trying to have sort of a mighty impact in one day, maybe every other week in the coming months. So you'll hear more about this for sure.
So just copy and paste this link to anywhere now and you'll have it and you can, the detailed information.
And
Rose?
thank you for doing it. We're trying to help and make sure that people aren't scratching their heads. What can we talk about? What can we talk about? So making it easy.
Right, and I just want to reinforce what Robin has said, and also to let people know that there are directions in this announcement about how to find your particular representatives at the federal, state, and local levels. And there are some directions about the best way to formulate a statement to your representative so that at least somebody in their office will read it. In addition to that, we really want to encourage people to just take the 5 or 10 minutes of your day to do one. If you just do one, that is, and not do 3, one is a big help. And I think all of us are looking for ways in which to have an impact, whether it is through writing legislators or going to demonstrations or meeting with legislators at candidate events. All of those things make a difference, and we need to make a difference. So we hope you'll join us as we do this every other week.
Thank you, Rose and Robin. Thanks for sharing that and thanks for doing that. Hear Our Voices Days are important.
Yep.
And it's been reinforced in today's this evening's program. Thanks everyone for being here and participating. As I mentioned, we'll stay on the line for open dialogue. If anybody has anything they'd like to say before we shut down, just raise your Zoom hand. But the official program is completed. And we are honored by Bob and Howard and the time you put into making this happen.